Okay, so when researching law, there are a few things that you need to watch out for. So a few questions that you need to ask yourself. If you don't, you can very easily end up finding the wrong law or applying it in the wrong way. So in a nutshell, you need to figure out, is it law? Is it my law? If it's not my law, can I still use it? Is there other more authoritative law? Is it still law? Does it mean what I think it means? Is it authorised, or is there more law? So the reason you need to think about these questions comes down to how the legal system works and how law is used within this system. So let's look at each in more detail. The first question to ask yourself is it law? So in law, there are two types of sources. So there's primary sources of law and secondary sources. So primary sources of law are where the law actually comes from, so where it's written down. So this includes legislation, so law made by Parliament or under the authority of Parliament, and case law, which are the written decisions of court cases, otherwise known as judgments. So secondary sources tell you about the law. They help you find the law, learn about it, understand it, and analyse it. So sometimes when you're searching for law, you'll come across a description of it in a secondary source. But if you want to cite what the law is, you shouldn't cite it from that secondary source. Instead, it will tell you what primary source that law comes from, and you should then go to that source, find that primary source yourself and cite that. So in our legal system, only primary sources can be cited as an authority. So when you go to court, you need to submit a list of the authorities, so the primary sources of law that back up the arguments you want to make. You will very rarely see secondary sources referenced in court decisions. The only time you might is if the case you're looking at, or the case is looking at a completely novel situation and there is no law as yet that covers it. So in this event, they can choose to look and see what academics have to say about the issue, but they're under no obligation to go along with what they say. So the upshot is, if you've only got a description of the law from a book or article, the answer to this question is no, and you have a bit more work to do. So the next question is it my law? So what we're talking about here is the concept of legal jurisdictions. So the idea that law doesn't apply to everyone everywhere, it only applies within a certain territory. So to understand what jurisdiction you're in, you need to understand a little bit about the legal system. In particular, who has the power to make laws for where you are. So in Australia, we have a federal system of government, so there are 9 jurisdictions. So each state and territory is a separate jurisdiction, and then there's the federal jurisdiction, which is sometimes referred to as the Commonwealth. So each jurisdiction has a legal system which has power to make laws. So this power comes from the constitution of each jurisdiction. This power can be limited though. So for example, in sections 51 of the Australian Constitution says that the federal parliament can only make laws about certain things. So things like tax, immigration, marriage, companies, etc. The states and territories can make laws on anything not covered by federal laws. Of course, every other country is another separate jurisdiction, plus there is an international jurisdiction. So this adds up to a lot of laws, but you only need to know about the laws from the jurisdiction your legal question relates to. So for something that happens in South Australia, we need to look out for acts and cases either from the South Australian Parliament or South Australian courts, or from the Federal Parliament or Commonwealth courts, depending on the area you're looking into and who has power to cover that area. Now, it's usually easy to tell if the law you've found is from the right jurisdiction. So for legislation, you can see it in the citation. So the part in brackets is the jurisdiction. For cases, the jurisdiction will be written somewhere at the top of the document. So again, the upshot is, if you have the law from a different jurisdiction, the answer to this question is no, and again, you have more work to do to make sure that there isn't any relevant law from within your jurisdiction. So what if it's not your law? Can you still use it? This question again gets to how law is used in our legal system, so what sources can be relied upon. The basic idea is that laws within a jurisdiction are binding on those within that jurisdiction, so courts have to follow it when making their decisions. They can still look at the law from other jurisdictions though, but this law is only of persuasive value. The courts don't have to follow it, they aren't bound by it. They can consider it and decide that it shouldn't apply here for any number of reasons. So if you're looking into a legal question and the law in your jurisdiction doesn't cover it, feel free to look at what the courts from another jurisdiction have to say, but you have to have a very good reason for doing so. Another question to think about is whether there is any other more authoritative law than what you've found. Now in law, there are 3 hierarchy of sources that you need to be aware of. The first relates to the federal system of law. So if the federal parliament and a state parliament both make an act about the same thing, the Federal Act applies. So the State Act is considered invalid. Now this does happen from time to time, and there have been cases where the state has taken the issue to the High Court to decide whether the Federal Parliament had the power to make the Act in the first place. So this means that if you find an Act from South Australia, but there's a possibility that the Federal Parliament has power to make an Act about the same thing, you should double check to make sure a Federal Act doesn't exist before you rely solely on the South Australian Act. The second hierarchy relates to the interaction between Parliament and the courts within each jurisdiction. Now, if there's an inconsistency between an Act and a legal principle set out in case law, you need to follow the Act. So courts can interpret and apply legislation, so they're often left to flesh out what an Act means and how it works in all different kinds of situations. But Parliament can pass an Act that then overwrites this. So they might decide that they don't like the way the courts are approaching things, so they then create an Act that sets out different legal principles. Or they might decide that they want to properly consolidate the legal principles the courts have established, and so they lay them all out in a new Act. So again, this means that if you find a case that seems to answer your question, you still need to make sure that there is not an Act which covers the same topic and says something different. So the third hierarchy relates to the court system. So each jurisdiction has a tiered court system. In the states and territories, there is generally a lower court, which hears small matters, an intermediate court, which hears more serious matters, and a Supreme Court, which hears the most serious cases. The High Court of Australia then sits above this. The federal jurisdiction also has a tiered court system, again with the High Court also at the top. Now, each court is bound by the decisions of the courts above it, so they have to apply the legal principle that the higher court sets out in the same way. But courts higher up the tier can change or overrule the legal principles set out by the courts underneath it, so they can decide that the legal principle isn't any good or should mean something different to what the lower court said. So again, this means that if you find an interesting case that seems really relevant to your question, you need to make sure that there isn't a case from a higher court that says something different. So luckily there are resources that are designed specifically to help lawyers do this. Now this segues nicely into the next question you need to ask yourself, which is it still good law? So law changes constantly, so acts get amended, legal principles set out in a case can be modified by later cases. But those old versions of acts and those old cases are still out there, so they don't get taken down because they do still have a use for historical legal research. So if you need to know what the law is today, you need to make sure that the law you have is still the law. So if you're looking at a case, as we said before, you need to make sure that there isn't a case from a higher court that says something different, or that an act was passed later that says something different. And if you're looking at an act, you need to make sure that it is the current version and not an older version. Now, don't let the year in the citation fool you. This just refers to the year the act was first passed, not when it was last changed. Another question you want to think about is, does the law that I found mean what I think it means? Because the answer can very easily be no. Law uses language in very specific ways, and you can't just assume that your understanding of a word matches with how it's used in law. Now, this is a very important aspect in reading and interpreting and applying the law, particularly legislation, and indeed statutory interpretation is a major skill that law students must master. Again, there are rules around how this must be done and resources that can help. The next question to ask yourself is the version of the Act or case that I'm looking at the authorised version? Now, this is different to the concepts of primary sources of law as a legal authority and authoritative in terms of the hierarchy of sources. Instead, this is about the version of primary sources that the courts prefer, so where you got it from. So when you go to court, you need to submit a list of the primary sources that support the arguments you plan to make. And where possible, they prefer you to cite the official version of an Act as published by the government, or a case as published in a specific law report series. Now, this doesn't really matter for non-law students. Any version of an Act or case is usually fine, but law students are expected to get used to this and only use and cite authorised versions of cases where they're available. So the final question you want to ask yourself is there more law? Are there any other legal principles that might apply that I need to know about? Now, problems are complex and so is the law. So a problem that you're looking at may have many legal aspects to it. So there might be different issues involved, and for each issue there will be different elements that need to be proved or different defences that could be used. So this means that if you find one legal principle that seems relevant to your problem, you shouldn't just stop there. You'll often need to look further to make sure that there are no elements that you haven't thought of. So those are some of the questions you need to keep in mind when researching the law to make sure that you're finding the right law and applying it in the right way.